Hi, and welcome to Legal Protections for Pregnant Workers and New Parents, presented by the California Civil Rights Department. A quick disclaimer before we get started. This guidance is for informational purposes only. It does not establish substantive policy or rights and doesn't constitute legal advice. This training is being recorded on November 7th, 2025. And so this training is based on the most recent guidance as of today, and it is the responsibility of the attendee to stay aware of changes in guidance and laws. An overview of what we will be covering. I'll talk a little bit about the California Civil Rights Department. We will talk about an important law in California called the Fair Employment and Housing Act. We will define and discuss discrimination and harassment. We'll also discuss reasonable accommodations for pregnancy, parental leave, reproductive loss leave, and lactation rights. I'll also share some resources with you from the Civil Rights Department to help support you after this training. So about the California Civil Rights Department. Our mission is to protect the people of California from unlawful discrimination in employment, housing, and public accommodations, and from hate violence and human trafficking. You may be familiar with us under our previous name, the Department of Fair Employment and Housing, but as you can see from our mission statement, we do much more than housing and employment. Those responsibilities include investigating complaints of discrimination and other civil rights violations. That is probably what you know us best for. Part of that is that we always try to help the parties work it out and by facilitating a dispute resolution process. So we have a group of folks who can help do that. When that doesn't work out, and sometimes rarely, we will prosecute violations in civil court. The department also issues regulations to provide greater clarity regarding the laws enforced by the Civil Rights Department. We collect data on the pay and demographics of large employers' workforces. We do what I'm doing now, which is to conduct outreach and training to inform Californians about their rights and obligations. We have a very unique unit here at the Civil Rights Department that works exclusively with communities and state and local bodies, and they help them to constructively manage conflict that has a community-wide impact. So something beyond what we mostly do, or you might be more familiar with us doing with individuals. Our ability to fulfill any of these responsibilities is based on our ability to meet folks where they're at. And so for folks with disabilities, they can request accommodations from the department to participate in any part of our process. The same is true of people who speak languages other than English or who feel most comfortable communicating with us in a language other than English. So now that we've talked about the California Civil Rights Department, let's talk about the Fair Employment and Housing Act. Now to discuss the employment laws enforced by the Civil Rights Department. The Fair Employment and Housing Act, or FEHA, protects employees and job applicants from discrimination and harassment on the basis of one or a combination of protected characteristics. We'll define that term in just a moment. FEHA also prohibits retaliation and requires that employers provide reasonable accommodations to folks with disabilities and people with religious beliefs. Importantly, FEHA applies to state and local government employers and private employers with 5 or more employees. There is an exception in FEHA for harassment. Employers of any size are prohibited from harassing staff. So even if an employer or a business generally does not have to comply with FEHA, they do have to comply with those harassment protections. The Civil Rights Department also enforces the Equal Pay Act, which says that employers can't pay an employee less than employees of the opposite sex or of another race or ethnicity for substantially similar work. Let's define protected characteristic. That is a personal trait, belief, or something about a person or group of people that makes up who they are, that is an important piece of their identity, and that is recognized and protected by the law from discrimination and harassment. An example would be race. The law protects people from discrimination based on race, and so race is a protected characteristic. California has many employment protected characteristics. We won't go through them all, but I do want to uplift a couple of important pieces here about FEHA. FEHA includes actually having these protected characteristics, but it also includes being perceived as or mistakenly believed as having these characteristics. The law does not want to make it okay for employers to discriminate against people just because they're wrong about who they're discriminating against. FEHA also covers association with others who have protected characteristics. So that's just kind of what it sounds like. If someone associates with someone that's in or that has one of these protected characteristics or is in one of these protected classes, and they're discriminated against because of it, that's also covered. What else does FEHA say? FEHA also provides protections to people in circumstances that are related to some of the protected characteristics that we just discussed, including the right of employees to take leave for a variety of reasons. That might include to care for themselves or a family member due to a serious illness, if the employee is disabled by pregnancy or a related medical condition, to bond with a new child, after the death of a family member, or after experiencing a reproductive loss. Some additional protections here under FEHA. There are employment protections for people with criminal histories. That's called the Fair Chance Act. There are also anti-discrimination protections based on the use of cannabis off the job and away from the workplace. There are also two, at this time, new-ish laws that are worth noting and important. One states that job advertisements, postings, applications, and other materials can't require applicants to have or provide a driver's license unless the employer reasonably expects driving to be one of the functions of the job, and the employer also reasonably believes that using some kind of alternative form of transportation, like public transit or a taxi or a bike, is not going to be comparable in terms of travel time or cost to the employer. And then lastly, there are time off and anti-retaliation protections for victims of certain violent crimes and their family members. There is a required notice that employers must provide to their employees and an accompanying frequently asked questions document that you can access on the Civil Rights Department's website to learn more. Now let's define discrimination, harassment, and retaliation within the meaning of the Fair Employment and Housing Act. Discrimination means treating a person differently, at least in part, based on one or a combination of those protected characteristics we just discussed. To prove discrimination, the person must experience some kind of harm because of their employer's actions or lack of action. Important to know here that inaction by an employer, so not doing anything or taking ineffective action, so action that doesn't really stop the discrimination, is going to create liability for that employer. Now, what might discrimination based on pregnancy or a related medical condition look like at work? Could look like refusing to hire someone or firing them, demoting them or cutting their hours, worsening their working conditions, perhaps as a way to get them to quit. failing to promote someone who is otherwise qualified, giving an undeserved negative evaluation, excluding the pregnant person from job perks or benefits or bonuses that other people receive, or refusing to grant a request for reasonable accommodations or for disability-related leave. Let's think about Josie's situation. Josie is a consultant at a financial planning firm, and she's 7 months pregnant. After disclosing her pregnancy, her boss starts excluding her from big projects and important meetings, which has never happened before. We want to consider here if Josie's employer broke the law. Possibly in this case. Josie is experiencing a harm, and that's called an adverse action, some kind of negative action, because of her employer's actions, right, in excluding her from those activities. More investigation is definitely needed here to determine if her employer's actions were, at least in part, due to her pregnancy. Now, let's define harassment. That refers to unwelcome words or behavior based on a protected category that threatens, intimidates, embarrasses, or demeans a person. This may affect their ability to do their job or otherwise undermine their personal sense of safety or well-being at work. When harassment is severe, very bad, or pervasive, happens a lot, and it alters a person's working conditions, it creates a hostile working environment. So again, for a hostile work environment to exist, harassment has to be severe, very bad, or pervasive. So happens a lot, so bad or happens a lot, and alters that person's working conditions. There is a somewhat recent California Supreme Court case that changes this area of the law a little bit, changes that standard. And what this California Supreme Court case said is that the one-time use of an unambiguous racial slur can create a hostile work environment. So that is a bit of a departure from what we just talked about. But the court was very clear that this relates to, again, the one-time use of what is an unambiguous racial slur. It can't be anything other than a racial slur. And again, the important exception here to FEHA, it is against the law for employers of any size to harass an employee or job applicant. Remember, that magic number in FEHA tends to be 5 with this very important exception. What might harassment based on pregnancy or a related medical condition look like at work? It may look like offensive or derogatory comments and jokes, or maybe offensive graffiti, cartoons, or images. In terms of who's responsible when harassment happens, generally if harassment is done by a supervisor, the employer is going to be legally responsible. If the harassment is done by a coworker or maybe a third party or an outside party, perhaps it's a business where customers or clients come in, an employer is going to be legally responsible if they knew or should have known about the harassment and failed to take appropriate action. It's important to note here that appropriate action is the standard. So the action has to have some kind of effect on the harassment, sort of shaking of the finger, something that really is ineffective in stopping that harassment is not going to keep an employer from liability. Let's talk about Kai's experience. Kai works at a grocery store. They are pregnant with a child conceived through in vitro fertilization, or IVF. Their coworker, Steve, believes IVF is unnatural. Steve repeatedly makes jokes about Kai's test tube baby and science experiment in front of other staff. Kai feels humiliated and offended. Kai tells the store manager, who encourages Kai to let it go because Steve's old school and he's a longtime employee. Considering what we just learned about harassment, do we think that Kai's employer broke the law? Yes, in this circumstance, Steve's comments are based on protected categories, including sex, medical condition, and reproductive decision making. That refers to the use of IVF. The comments that Steve made were severe, they were really bad, really offensive, and pervasive. They happened all the time, and it really impacted Kai's sense of well-being at work. Their employer knew about the harassment, but failed to take action to remedy the situation. So in this case, the employer is very likely liable for Steve's harassment of Kai. Let's turn now to discuss reasonable accommodations for pregnancy. What is a reasonable accommodation? This is something that's required by California law, and employers have to reasonably accommodate an employee for a condition related to pregnancy, childbirth, or a related condition if the employee requests it on the advice of their healthcare provider. An accommodation is some kind of modification or change to the workplace that ensures a person with a disability can perform the essential functions of their job and enjoy the same benefits and privileges of employment as their colleagues who do not have disabilities. What might a reasonable accommodation look like at work? For a pregnant worker in particular, perhaps additional break times to use the bathroom to rest or to eat. Maybe allowing water or food at their workstation, or providing flexible hours, or a stool or a chair for them to sit on. Maybe it's time off for medical appointments or a temporary modification of their work duties. It could also look like a temporary reassignment to a less strenuous or hazardous position. How does a person request an accommodation? So pregnant workers must give sufficient notice of their need for a reasonable accommodation. And the law defines sufficient notice as 30 days advance notice if the need for the accommodation is foreseeable, or if it's an emergency, as soon as practicable. So the law does realize and acknowledge here that sometimes accommodations for pregnancy may be known in advance, and at other times there may be emergencies. But the important part here is that the pregnant worker has to give notice of their need for an accommodation to their employer. After receiving that request, employers may require the worker to submit written medical certification of the pregnancy or related condition in order to grant the employee's request. Anytime a reasonable accommodation is requested, anytime a pregnant person makes clear that they need some kind of change in the workplace because of a pregnancy or related disability or condition, that triggers the interactive process between the person requesting the accommodation and their employer. This is an exchange of information about whether and or how accommodations can be provided. It can include brainstorming about accommodation possibilities, and really you can think about this like a good faith negotiation. Everyone's coming together to try to figure out how to accommodate a person so that they can do their job well and safely. That sometimes can be challenging. So another really important piece of the interactive process is that it is ongoing. If an accommodation turns out not to be effective, then that means the discussion resumes so that, again, the person with the disability can do their job safely and well. Now, this would include disclosing a pregnancy sometimes. So employees and job applicants are not required to disclose that they are pregnant. It's up to them when they want to do that. However, related to accommodations, if that person wants to request a reasonable accommodation related to their pregnancy or pregnancy disability leave, they may be required to disclose their pregnancy in order to give their employer sufficient notice of that need for leave. Let's talk about Deandra's request. Deandra's 30 weeks pregnant and she works in retail. She's experiencing preeclampsia. That's a serious blood pressure condition that can develop during pregnancy. As a result, Deandra is sensitive to light and she sometimes has blurred visions. Her symptoms are starting to make it challenging to ring up customers. Deandra requests to be taken off the register for the remainder of her pregnancy. Now let's ask ourselves if Deandra's employer is obligated to grant that request. Maybe. The answer here is maybe. Deandra's employer definitely has to engage in the interactive process with her to find a solution that works for everyone. Taking Deandra off the registers temporarily may end up being the best solution, but certainly Deandra and her supervisor can explore other types of solutions, like maybe eyeglasses that block the light or ease her eye strain. Maybe it's more frequent breaks to rest her eyes, or perhaps it's reassignment to a less busy department or register. And finally, let's discuss and define retaliation. That occurs when an employer punishes an employee or treats them unfairly, at least in part, because they exercised a protected legal right. That means that they did something that they have a legal right to do, and because of that, their employer has punished them somehow. What might exercising a protected legal right look like? It could mean filing a complaint with the Civil Rights Department or helping someone file a complaint. It could mean cooperating with an investigation into harassment or discrimination. Could mean telling your supervisor about harassment or discrimination that you experienced or witnessed. Important too, no magic words there. Employers should be trained to spot harassment and discrimination when it's being described by an employee. A legal right could also include contacting a lawyer or a nonprofit for advice about harassment or discrimination at work. So all of those things are examples of activities that people have a legal right to do. And if they engage in those things, and because of their engagement in that, they are punished, they've experienced retaliation. Let's move now to a discussion about parental leave protections in California. The Fair Employment and Housing Act provides two types of parental leave: pregnancy disability leave, or PDL, and bonding leave under the California Family Rights Act, or CFRA, CFRA. These types of leave are unpaid unless an employer voluntarily provides the pay. But these laws do provide job protection for eligible employees. This means that the employee can expect to be reinstated to the same or a comparable job after they finish their leave. There are some exceptions in limited circumstances unrelated to leave, like a layoff. So important to know here that these types of leave are unpaid, but do provide job protection, so an ability to return to that job. So let's dig into these two types of parental leave. Pregnancy disability leave. We'll start here. We'll talk first about eligibility. To qualify for pregnancy disability leave, an employee has to work for an employer with 5 or more employees. They must have a pregnancy-related disability. And an important exception here: non-birthing parents are not entitled to pregnancy disability leave. This is limited to the pregnant person. Pregnancy disability leave can be made available for time off for prenatal or postnatal care, severe morning sickness, doctor-ordered bed rest, childbirth and also recovery from childbirth, the loss or end of a pregnancy, or any other related medical condition. keeping on with pregnancy disability leave, eligible employees get up to 4 months of leave based on the hours worked per week and the duration of their disability. Now, importantly here as well, the leave can be taken all at once, the whole 4 months at once, or intermittently. So that means piece by piece. Employees must give their employer at least 30 days of notice if they intend to use pregnancy disability leave, if possible. And we've talked about this a little bit, but let's finish up pregnancy disability leave by talking about pay and benefits. Employers are not required to pay employees who are using pregnancy disability leave, but they can certainly choose to. Employees may get paid by using accrued paid time off, like vacation time, or if they qualify for state disability insurance through the California Employment Development Department. Most folks have heard of EDD, so certainly EDD has a part to play in this that does not include any of the protections that we've been talking about regarding discrimination, retaliation, things of that nature. Employers may require employees to use sick time unless they're receiving state disability insurance. So there may be some differences there in terms of leave sick time being used. And employers must continue to pay for health benefits if they provide them while that person is on pregnancy disability leave. Let's turn now to the California Family Rights Act and let's dig into eligibility. Again, folks are eligible for this if they work for an employer with 5 or more employees. They must have a new child via birth, adoption, or foster placement. This also applies. A person can also use California Family Rights Act leave to care for their own serious health condition or the serious health condition of certain family members or of a designated person who has a very close or family-like relationship to the person. To be eligible for California Family Rights Act leave, an employee must have worked for the employer for at least 1 year and have more than 1,250 hours of service in the past year. So to qualify for CFRA leave, for California Family Rights Act leave, it's really important to have those dates and that information available. Now, both parents, including fathers, adoptive or foster parents, or same-sex parents, are entitled to Family Rights Act leave, even if both parents work for the same employer. And recall that this is different from pregnancy disability leave, which is only for the pregnant person. Now, what about timing and duration of Family Rights Act leave? Eligible employees can get up to 12 weeks of leave, and that must be taken within 1 year of the child's birth, adoption, or their start of foster care. Now, a person can certainly use both pregnancy disability leave and California Family Rights Act leave. And important to know here that California Family Rights Act leave is going to start running after pregnancy disability leave. So pregnancy disability leave is used first. This type of leave can be taken all at once, the whole 12 weeks, or in 2-week increments, so in 2-week pieces at a time. Employees may take leave in smaller increments if or when the employee or their family member or designated person is incapacitated or the employee is unable to perform an essential function of their job because of a chronic, serious health condition. So generally, leave is taken all at once or in 2 weeks, but there are some exceptions there, really, really specific exceptions. And again, sounds similar to pregnancy disability leave. Employees must give their employer at least 30 days notice of their intent to use this leave, if possible. What about pay and benefits? Same here with the pregnancy disability leave. Employers are generally not required to pay employees who are on leave under the California Family Rights Act, but again, they can certainly choose to. And some municipalities, so some cities or counties, may actually require employers to pay employees who are using this type of leave. Employees can get paid by using their accrued time off, so like vacation time, or if they qualify for paid family leave, again through the California Employment Development Department, or EDD. Employers may require employees to use vacation time unless they are receiving paid family leave. And employers may not require employees to use sick time, but both parties, so the employer and the employee, can mutually agree that the employee can use sick time. So important to know here that vacation is going to be the default, but everyone can agree instead to use sick time. And again, similar to the previous type of leave discussed, employers must continue to pay for health benefits if they provide them. Let's talk now about Simon's situation. Simon and Jeanette work at the same large company. 2 years after Jeanette starts her job, they are overjoyed to learn that she's pregnant. In her 8th month of pregnancy, she experiences severe nausea and her doctor orders bed rest. Their employer grants Jeanette's request for pregnancy disability leave. Simon also requests pregnancy disability leave to help care for Jeanette. Their employer denies Simon's request, saying that Jeanette is already on leave, so Simon cannot also request the same kind of leave. So let's think about Simon's situation in regard to what we just learned. Did Simon's employer wrongfully deny his leave request? No, Simon's employer was correct in not granting Simon the leave that was requested, but the employer's reason for doing that is wrong. So while Simon's employer is correct in denying Simon's request for pregnancy disability leave, the employer's reason is wrong. Non-birthing parents like Simon are never going to be eligible for pregnancy disability leave. That's only going to be available to Jeanette as the pregnant person. However, based on how long he's been employed, Simon is eligible for leave under the California Family Rights Act to help care for Jeanette because it's his wife and she has a serious health condition. Simon is also eligible for Family Rights Act leave to bond with their child after the child is born. So both parents here, Simon and Jeanette, are entitled to leave under the California Family Rights Act, even though and even when they work for the same employer. So the employer came to the right result here, but got there in the wrong way. So it's very easy to make a misstep in the next situation because it may not turn out correct. Now let's discuss another type of leave available, which is reproductive loss leave. Most employees are going to be entitled to up to 5 days of leave after they experience a reproductive loss. And that's defined as a miscarriage, stillbirth, failed adoption, a failed surrogacy, or an unsuccessful assisted reproduction. So like a failed insemination or embryo transfer. Let's talk about who is eligible for reproductive loss leave. Similarly to what we've been discussing, an employee must work for an employer with 5 or more employees. They must have worked for the employer for at least 30 days before taking leave. So this is a much lower standard for having worked at a place than the type of leave that we've discussed previously. And employees are going to be eligible for reproductive loss leave as long as they would have been the parent of the child born or adopted. even if their partner experienced the reproductive loss. So both parents here, whether that's through surrogacy, through adoption, someone with a parent-like relationship can request leave. How about the timing and duration here of the reproductive loss leave? Again, eligible employees get a minimum of 5 days of leave for a reproductive loss event. They can, but they are not required to take all of their leave days consecutively, so all at the same time, all in a row. Leave must be completed within 3 months of the reproductive loss. And when a single reproductive loss event occurs over several days, which does sometimes happen, the law treats this as one event, not as multiple reproductive losses. If an employee experiences more than one reproductive loss in a year, they are entitled to no more than 20 days of reproductive loss leave in that 1 year period. So this is another important thing to note. Some folks do have disabilities or reoccurring issues, and so there is a cap on that particular amount of leave. However, certainly an individual employer's leave policy may provide for more time, absolutely within the authority of the employer to provide more time. Now, if an employer has an existing leave policy that applies to reproductive loss events, then the employee must take that reproductive loss leave according to that specific policy. An important thing to consider and remember here is that reproductive loss leave is separate from leave under the California Family Rights Act and pregnancy disability leave. If an employee experiences the reproductive loss while they're on another type of leave, they are allowed to take reproductive loss leave within 3 months of finishing that other form of leave that they were on. So that reproductive loss leave does not go away just because the person may have already been on leave at that point. But they have to take that leave within 3 months of that other form of leave ending. How about pay and benefits regarding reproductive loss leave? If an employer doesn't have an applicable paid leave policy, employers must let employees use any available vacation time, sick time, personal days, or paid time off to cover their reproductive loss leave so that they can still get paid. Otherwise, reproductive loss leave may be unpaid. Now, obviously, this is a very sensitive subject, and so employers are required to keep any information that an employee provides when exercising their right to reproductive loss leave confidential. Employers may disclose information when required by law or to internal personnel or to legal counsel when necessary. Otherwise, this information should be kept very, very confidential. FEHA, the Fair Employment and Housing Act, does not require that employees provide documentation of their reproductive loss event. Pregnant people, birthing people do not always have reproductive loss events at a hospital or in a hospital type setting. The law recognizes that and acts accordingly. Lastly, we are going to discuss lactation rights. There are specific lactation rights at work to express breast milk or chest milk. The Fair Employment and Housing Act protects lactating parents from discrimination and harassment at work. To accommodate workers, employers are required to provide reasonable break time for a person to pump, which is meaning to expel their breast milk, even if pumping requires additional breaks that are longer than normal. Employers are also required to provide a clean, private space close to a refrigerator and a sink that has an area to sit, a surface on which to place the equipment, the pump, electricity to be able to plug that in if needed. There is an exception here to this requirement to provide this space. An employer is not required to provide a lactation space with all of these elements if the employer has less than 50 employees and that employer can show it would be extremely difficult to meet one of these requirements. So the requirement to provide a clean and private space near a refrigerator and sink with surfaces, areas to sit, and electricity. I appreciate you getting through the substantive part of the training, the meat and potatoes of the training, and I'd like to leave you with Civil Rights Department resources that can serve and support you beyond this recorded training. The California Civil Rights Department has a ton of written resources on pregnancy disability, on different types of leave. You'll see a couple of examples here on your screen. Our pregnancy disability leave fact sheet, our family care and medical leave fact sheet, and also a required poster about the rights and obligations of pregnant employees. We also have a sample medical certification template form that folks may want to use to document their leave request. That's available on our website as well. And we somewhat recently published a fact sheet on leave from work after a reproductive loss, and that's available in a variety of languages. We also have a couple of quick reference guides for folks who want to take a quick look at the comparisons between different types of leave, like pregnancy disability leave and California Family Rights Act leave and leave provided by the federal law called the Family and Medical Leave Act. So this is a kind of handy dandy chart that helps to break down some of what we just talked about in terms of duration and pay and benefits. So this is a really, really great resource for folks. We also have an interactive guide for new parents. So if a person is pregnant, they're a birthing parent, they're the non-birthing parent, they want to know a little bit about time off or bonding leave, they can go through this interactive guide and get a very specific, unique, and tailored letter based on their responses that can help to guide them in understanding what type of leave they're entitled to and when they can take it. I appreciate that you're here watching this on YouTube, and if you'd like to join one of our live webinars, we have 3 webinars a month. They happen on Wednesdays. Visit CRD's website to sign up for all of our offerings. Thank you for finding us here on YouTube. I know that you can find our channel, and I really encourage you to dig into the resources there. We have a ton of webinars that are recorded on lots of different issues. So please do spend some time with that and check that out. And with that, I want to thank you for empowering yourself through education, spending some time here with the California Civil Rights Department. We thank you and we appreciate you whenever and wherever you are. Thanks so much.